Sir, begin proceeding. Namaskar and a very good morning to everyone present here. I, Abhilash Sanapati, Registrar Records, High Court of Orissa, extend my heartiest greetings to all our honorable guests, judicial officers, officers of the registry, officers of the Odisha Judicial Academy, State Legal Services Authority, government officials, members of print and electronic media, and all the distinguished dignitaries present today at the release of Annual Report 2022 and District Judges Conference. On this August occasion, with immense pleasure, gratitude, and honor, we welcome our esteemed guest to India's best kept secret, the sacred land of Lord Jagannath Odisha. On this August occasion, it is indeed our proud privilege to have amongst us His Lordship Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India, who has been kind enough to grace this occasion as our chief guest. We are indeed fortunate to have his gracious presence amongst us on this resplendent occasion. May I now humbly request His Lordship Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India, to kindly adorn the dais, and I request the Registrar General High Court of Orissa to kindly conduct His Lordship to the dais. Sir. May I now humbly request Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, to kindly adorn the dais, and I request the Member Secretary, State Legal Services Authority, to kindly conduct His Lordship to the dais. Sir. May I now humbly request His Lordship Honorable Mr. Justice Subhashis Talapatra, Judge High Court of Orissa and Chairman of the District Judges Conference Committee, to kindly adorn the dais, and I request Registrar of Vigilance High Court of Orissa to kindly conduct His Lordship to the dais. Sir. May I now humbly request His Lordship Honorable Mr. Justice Shashikanta Mishra, Judge High Court of Orissa and member of the Annual Report Committee, to kindly adorn the dais, and I request the Registrar Inspection High Court of Orissa to kindly conduct His Lordship to the dais. Sir. We are also fortunate to have amongst us judges of the High Court of Odisha. My lords, our heads bow down in gratitude for your lordship's gracious presence in this august occasion. We are also blessed to have amongst us former judges of the High Court of Odisha. My lord Pranam. May I now seek the permission of our chief guest, His Lordship Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India, to kindly declare the event as open. Thank you, my lord. The event is declared open. As a mark of our heartfelt gratitude, may I now request Civil Judge Sri Sitesh Mahanti to kindly present a bouquet to His Lordship, Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India. As a mark of our acknowledgement, may I now request Civil Judge Ms. Samiksha Shah to kindly present a bouquet to Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa. As a mark of our heartfelt gratitude, may I now request Civil Judge Sri Animesh Jana to kindly present a bouquet to Honorable Mr. Justice Subhashis Talapatra, Judge High Court of Orissa and Chairman of the District Judges Conference Committee. May I now request Civil Judge Ms. Pratibha Das to kindly present a bouquet to His Lordship, Honorable Mr. Justice Shashikanta Mishra, Judge High Court of Orissa and member of the Annual Report Committee. We shall now begin the program by rendering of the state song written by Odia poet Kantakavi Lakshmikanta Mahapatra's Bande Utkal Janani. Ladies and gentlemen, I would request everyone to please stand as a mark of respect for the state song of Odisha. Now we begin with the event. So may we now request My Lord Honorable Justice Subhashis Talapatra, Judge High Court of Orissa, and Chairman of the Decisions Conference Committee to kindly present the welcome address. My Lord.
Good morning to all. In this annual conference of the district judges of the state of Orissa, and I welcome especially Justice Sanjeev Khanna, Judge of Supreme Court of India, a judge having a great heritage, and in his journey to this ascensions to the apex court of the country. Justice Khanna, as we say, the judge is known by his judgment. I feel a little bit of one line from one of his judgment may be relevant in the present day's context, as we all know this country is going through a noisy democracy. Justice Khanna in Amish Devgan versus Union of India made a very remarkable comment, which I read. Article 19(1)(a) cannot be pressed into service for defeating the fundamental rights guaranteed by Article 21, as no one claims to right to speech, the others have the right to listen or decline to listen. Welcome, my Lord, in this conference, and we extend our heartfelt gratitude to you. I also welcome our illustrious Chief Justice, Justice S. Muralidhar, who is the brain behind this conference, and he has actually chalked out the design of this conference. We welcome you, and both of you has spared your valuable time to attend this conference. I also welcome my fellow brother judges and sister judge, and also the retired High Court judges who adorn this High Court and part of the history of the glory of this High Court. And most importantly, the delegates of this conference, the district judges from the 30 districts of the state of Orissa. As we say, the district judiciary is the bedrock of the judicial institution. You represent that bedrock, and the purpose of this conference are manifold: to churn out the experience that you have gathered, make into it, infuse it in the policy decision making for the next years to come. And that is a very important and significant exercise for any judicial institution. Throughout these 2 days, we will be deliberating upon multiple subjects, including the implementation of the ICT, best practices, gender sensitization, process re-engineering, supervisory mechanism, gender sensitization, and the court management, process management, challenges from the social media, fiscal management, including budgeting and the development of the infrastructure, and also other difficulties that you may like to raise and you may like to place for the consideration of the conference. Beyond that, I will make certain 2-3 quick comments that is very important. One of those are that the frivolous litigation. That is a very important part. If you try to actually see that the areas of the cases should be managed in a certain level, then at the entry of the litigation, we must be very vigilant so that the frivolous litigation can be scuttled at the earliest stage. Supreme Court in a recent judgment has observed the justice dispensation machinery in India is plagued with the backlogs, with 70% pendency before the subordinate courts being on the criminal side. A significant factor in this backlog is the vast mass of frivolous litigation instituted year after year by litigants with intent to use the courts of justice for their own mischievous ends. Thereafter, this other important point that because we are looking at a futuristic judiciary in our country. We have the technology, information technology now adequately in our command, So use this technology for purpose of this planning the court and the cases. This the activity-based costing. This is an idea that has been adopted by the UK judicial system. I find that you can also ponder over this system, which is modeling on the activities and tasks relating to the categories of cases in each judicial jurisdiction. Measures of working time are estimated for each activity and case category. The results are the used to weigh cases for monitoring purpose. I like to mention also that this system not only relate to the courts as a whole, but to individual judges. We are in our command the data mine of the NGDG and the CIS, the Court Information System. There we can find the detailed information to assess our own performance in a particular jurisdiction. It requires certain kind of attention to just plan how to eradicate the areas and also upgrade ourselves to take in the new challenges of the laws, new challenges of the society. And this judicial institution, Orissa Judicial Academy, at the very bold initiative of our Chief Justice, will be decentralized, and we have already started working on them. There will be the regional judicial academies. And it is coming up, everybody knows. The core areas of this continued learning, I call it as a continued learning, would be substantive law, evidence, procedure, and where appropriate, subject expertise. The acquisition and improvement of the judicial skill, including where it is appropriate, leadership and management skill. And also, importantly, I draw your attention to the social context within which judging occurs. That is another important area of studying. And when I talk all about these things, whether we are accountable to the system, whether our performance can be assessed and measured by any standards. I think there are standards. Globally, these standards are accepted. I will just placing this basic 10 standards are followed all over the country, particularly the developed democracies. These are how we are helping access to justice, to the expedition in disposing the cases, timeliness in disposing the cases, equality, treating the persons coming to the court, stakeholders equally, fairness, integrity of the individual as well as of the institution, independence of decision-making process, and it should also be read with accountability and the public trust and confidence. These are 10 measures would be tools for assessing our performance everywhere. For this, we need to change our minds. The taste of change of mindset is one should enjoy work rather than do work. When a judge does work without enjoying, it will amount to formal adjudication of cases without change of mindset in traditional manner. But when the soul of a judicial officer starts enjoying working, he will be a detached, dedicated judge with change of mindset. It is only possible when the existing judiciary is trained not only in legal spheres but with ethical norms as well. From the above, these comments that I make, I can say the change of mindset, and I also say it is a development of faculty of brain for enjoying work. It is only possible with socio-legal ethical training and regular practice of doing detached hard work. By practicing hard work with enjoyment, it will develop in habit for enjoying work, which is a requirement of time. When I talk about the change of minds, I am indicating to the role of the district judges in mentoring the officers who enters in the judicial institution and they grow up in the institution. You put the example by yourself, and that will be the great learning from those officers. I think you will be enjoying the conference. And again, I express my gratitude to Justice Sanjeev Khanna, Honorable Judge of the Supreme Court, our Chief Justice, Justice Muralidhar, and all of you. Thank you, everyone. Thank you very much.
Thank you, my lord, for the warm and heartfelt welcome extended to our honorable guests. May I now humbly request Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, to kindly render his address to this august gathering. Sir.
Pranam, Vande Utkala Janani. A very warm good morning to all of you. This is Sanjeev Khanna, Judge Supreme Court of India. I can't tell you how happy you've made all of us this morning with your presence here. It has meant a lot to not only me and my colleagues present here, but every one of the judicial officers present. Two words that can describe Justice Sanjeev Khanna accurately: discipline and total dedication. So discipline and dedication marks Justice Sanjeev Khanna. In the most hardworking Supreme Court of the world, which is the Supreme Court of India, you have a very hardworking judge who's so conscientious. He's very, very particular on punctuality, on every aspect a judge would want. Best qualities that you look in a judge, I think Justice Sanjeev Khanna epitomizes many of those qualities. We've been fortunate to be colleagues in the Delhi High Court. We were together at a time when we had excellent role models before us. And I'm hoping that through these district judges conferences, we identify the best practices amongst us and try to emulate those best practices. This is a wonderful opportunity to share your ideas, your experiences. So Justice Khanna will be happy to know that in the format of this district judges conference, we allow the judges to speak, the district judges, the chief judicial magistrates to speak. So in every session, we will begin with presentations by them and then response by us in the High Court. And therefore, there is a dialogue forged. And the last time the district judges conference was held, it was revived after a gap of almost 10 years. We got some very, very important learning from that conference. 3 or 4 themes emerged. For all of us, and I must confess, for all of us as High Court judges, some of us coming from the bar, it was an eye-opener. We did not know how complex it was, the whole functioning of the district judiciary. And what we learned from that district judges conference, we were able to implement, one of them being this rationalization of case distribution. That learning came from the district judges. So through you, I want to thank all the district judges who participated, the other judicial officers who participated in the previous year's conference, because that has helped us achieve results far better than 2021 in 2022. Collectively, the district judiciary has disposed of as many as 5,15,392 cases with a case clearance rate of 93.20%. And this is over 2,38,588 in 2021. So I think you can justifiably give yourselves a big pat on the back. Well done. Collectively, the district judges have delivered 1,61,263 judgments. And Justice Khanna will appreciate this also because he's been talking about it so often. We've had so many conversations of this. Many of these are contested judgments. So he's always emphasized on contested judgments. He's deeply conscious of how district judges work. So it's absolutely befitting that we have Justice Khanna launch this district judges conference of 2022. The other important thing I wanted to highlight is the role of my own colleagues. Each of the judges of the High Court, they've been completely involved hands-on. Apart from inspecting all the judges under their administrative control, they've been sitting in committees, they've been giving very valuable inputs, they've been interacting with the judges on a person-to-person basis to get the best performance from each of the judicial officers. So a big thank you to each one of my colleagues. Without your complete dedication and devotion, I don't think we'll be able to achieve much of what we've been able to achieve in the last 2 years. Another very important aspect of this conference, like it was in the previous conference, is, of course, the launch of the annual report, basically a report card we put out to the public. This is, I think, something again very dear to Justice Khanna, accountability and transparency. So we've been emphasizing it. In fact, yesterday when we met, he said, okay, what we wanted to do in Delhi High Court, you've done it here. So he's very deeply appreciative of all the steps that we've taken to make this judiciary, the Odisha judiciary, more accountable to the people, more transparent in its functioning, and it has earned the appreciation of everyone, nationally and of course in the state. We find more satisfied litigants, but it's very important that we don't become complacent. I know we've set out in a very important path here. Each of you as judicial officers, each of you as chief judicial magistrates, as district judges, you've already spent quite some time in the judiciary, perhaps more than a decade, some of you maybe 2 decades. This delivering justice is the challenge. Delivering justice, as Justice Talapatra was pointing out, in a fair, non-discriminatory way is the real challenge. Delivering justice that is still relevant to the people, where people do not feel negated or ignored by the system. That is the challenge each of us faces, and that mission has to go forward. You've done excellently well in 2022. This annual report showcases your wonderful work, and I hope we can carry it forward. 2 features I wanted to highlight which has been showcased in the annual report. One is the incentivization of the district bar. So last year we instituted what is called the Lawyer of the Year Award, and we were able to identify 22 lawyers in the districts who've actually satisfied a large range of parameters chosen by their peers. This was by a jury in each district, headed by the district judge, but 3 senior members of the bar and the chief judicial magistrate in each district. So thank you, both the district judge and the CJM, for helping us identify those 22 trial court lawyers who will probably be the hope for the future for the entire legal system in Orissa. The second aspect of the annual report of 2022 is that we showcased what we identified as best performing districts. We've divided the 30 districts in Orissa into 3 zones, depending on the judge strength in each district. So of these 3 zones, I'm very happy to announce in zone A, the Judgeship of Balangir has been adjudged as the best performing district. In zone B, Nayagad has been adjudged as the best performing district. And in zone C, Devgad has been adjudged as the best performing district. The annual report explains in great detail the parameters we set out for adjudging this. I must thank the committee which sat painstakingly, not only drew up these parameters, but also adjudged, and in the most fair and transparent way, of course, helped by our registrars, the Registrar General, who's guiding the Registrar Administration, the Registrar Inspection, our coordinator of the Arbitration Center, Soumya Patra. All of them have worked very hard to make sure that this event has happened, and this will be probably setting an example for the future, where we incentivize good work done by judicial officers. But what I most want to emphasize is it's not the work of just one person or a few persons. Each of the district judges who have headed these 3 districts will tell us that it's a teamwork. They've inspired all the judicial officers working their districts to work collectively as a team. It's very evident when we see the parameters what teamwork can achieve. And that should be the spirit with which we work. It is not that the other districts have not performed well when we acknowledge these 3 districts, but collectively, the Odisha judiciary is headed on the right path. In the last 2 years, there's been a progress forward. Again, this progress forward is due to the tremendous work done by the judicial officers, their staff, the judicial officers who've come to the High Court on deputation. We have the Registrar General, of course, the Registrar Administration, the Registrar Judicial, the Registrar Inspection, all of them who've contributed, and literally they're all working 24/7, 365 days a year. And this is all only to make the judiciary function in a more accountable, more transparent way and a more efficient way. I must also thank the lawyers who've made all of this possible. We've had the district court lawyers participate in a big way. We've had the High Court lawyers participate in a big way. All of this is contributing to the way the Odisha judiciary has been able to march forward. I can go on and on, but I am, like all of you, waiting to hear Justice Khanna. So thank you for your patient listening. Thank you for a wonderful beginning we have for 2023, inspired by what we've been able to do in 2021 and 2022. Before I end, I want to highlight one last part of this annual report, which you may not find in other annual reports. There's a whole section on the artwork in the High Court. And I specifically want to thank Mr. Avinash Khemka, who's here with us, for contributing those wonderful photographs of the artwork to our annual report. It has enhanced the quality of the annual report. And I also want to thank, apart from the annual report committee itself, headed by Justice K.R. Mahapatra, and with the participation of Justice Rautre, Justice Sashikant Mishra, Justice Chittaranjan Das, for literally working day and night to bring out this annual report, which you will see in a very few minutes from now. Thank you, all of you, for making this event happen. Vande Utkal Janani and Jai Hind.
Thank you, my lord, for the warm and heartfelt address to our honorable guests on the importance of DJ conference, highlighting the annual report and the words of encouragement along with your constant guidance. I would now seek permission from the chair for presentation of the best performing district award. Sir. Thank you, sir. I would now request Sri Lalatendu Jena, Discharge Balangir, and Sri Himanshu Sekhar Singh, CJM Balangir, to kindly come to the dais, and I request His Lordship Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India, to kindly present the best performing district memento for Zone A to the Discharge Balangir, and I would request Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, to kindly present the best performing district certificate for Zone A to the CJM Balangir. Sir. I would now request Madam Rupashri Chaudhary, Discharge Nayagarh, and Srimati Pragya Paramita Mahapatra, CGM Nayagarh, to kindly come to the dais, and I would request His Lordship Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India, to kindly present the best performing district memento for Zone B to the Discharge Nayagarh, and I would request Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, to kindly present the best performing district certificate for Zone B to the CGM Nayagarh. I would now request Sri Gautam Sharma, Discharge Devgarh, and Sri Sarbeshwar Das, CJM Devgarh, to kindly come to the dais, and I would request His Lordship Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India, to kindly present the best performing district memento for Zone C to the Discharge Devgarh, and I would request Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, to kindly present the best performing district certificate for Zone A to the CJM Devgarh. Zone C. For Zone C. To take matters ahead, it is my utmost honor to humbly request His Lordship, Honorable Mr. Justice Sanjeev Khanna, Judge, Supreme Court of India, to formally inaugurate the Discharges Conference 2023 and release of Annual Report 2022. My Lord. This one in the process. How? I now request with immense pleasure and gratitude His Lordship Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India, to present the inaugural address to this august gathering. My Lord.
Yes, okay. Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, Mr. Justice S. Mahapatra, Mr. Justice S. Mishra, sister and brother judges of the Orissa High Court, retired judges of the Orissa High Court, and judges from the district courts. Namaskar. When Justice Muralidhar called me for coming over here and inaugurating this conference, my first reaction was, what's the need? You have an excellent and a humble Chief Justice, a noble person, who's an excellent orator. But there was some persuasion by him, but more than that, there were two other reasons why I came over here. Orissa is a gem in the crown of India's culture. And my two visits earlier, 2 or 3 visits over here, had left a deep imprint. Be it the Sun Temple in Konark, or what we have in our national emblem, the Ashokan pillar. The second reason was more personal. My father was a member of the judiciary in Delhi, erstwhile Punjab judiciary and then the judiciary in Delhi. He was a civil judge, then went on to be a district judge, and then retired as a judge of the, after elevation as a judge of the Delhi High Court, retired as a judge of the Delhi High Court. And my memories of the childhood, I had seen him, the amount of work pressure as well as complete commitment to work and hard work. In fact, I used to joke with my children and tell him, I've never seen him sleeping. He was always with the files. The second reason again was my introduction to law was from district courts. And my foundation was built by the judges in the district court. I'm always indebted to them. Whatever I have achieved, I don't think I would have ever achieved it had I not gone to the district courts and seen the working and also taken the benefit of the guidance and help in form of correcting the young lawyers, corrections as a young lawyer I got when I was appearing in the district courts. So my address is primarily meant for the district judges, and that too on the area of criminal law, because I was given to understand that majority of the litigation over here in district courts in the criminal side. Often, as judges, we come across a litigant who, in the fact situation, asks us the question, what can I do? And invariably, our answer is, what can we do? This, according to me, is the basic flaw which happens when we don't appreciate and turn our backs to the litigants who have come to the court expressing helplessness. The answer, in my opinion, is to make a difference and adopt what I call is positive adjudication, which means willingness and desire to rectify and resolve the problem. And until unless that is percolated and accepted by the judges, we will not be able to give justice to the litigants who come to the court. If one looks at the Constitution, which I feel is a sacred text for all of us as judges, this is repeatedly embedded in different articles of the Constitution. Because I'm redressing primarily on the criminal aspects, I'll be referring to some of the articles which are relevant as far as criminal adjudication is concerned. Article 38, which is part of the directive principles of the state policy, reads, the state shall strive to promote the welfare of the people by securing and protecting a social order. I'm skipping some words. A social order in which justice, social, economic, and political shall inform all the institutions of the national life. Article 39A, which primarily deals with legal aid, says, the state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity to ensure that the opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Article 21 says that no person shall be deprived of his life or personal liberty except according to procedure established by law. The later portion of this section, this article, according to procedure established by law, I'll be addressing slightly later. Article 14 says, the state shall not deny to any person equality before law or equal protection of laws within the territory of India. Article 21(1) says, no person shall be arrested, no person who is arrested shall be denied the right to consult and to be defended by a legal practitioner of his own choice. When we read Article 22(1) along with Article 14, it means that where a person is not able to afford a legal practitioner of his choice, still the person must be given equal protection of all laws. Then, if one goes through these articles, the word which is repeatedly used therein is justice. The question is, justice can have various connotations and meanings, but as far as justice in criminal system is concerned, it means that justice means existence of rules that provide a right to a fair and a just decision, rules that provide an equal and a fair opportunity of winning against the most powerful and against the state itself. Justice Muralidhar was earlier a judge of the Punjab and Haryana High Court. I have, if you look at the screen, the emblem of the Punjab and Haryana High Court. The emblem is not a balanced one with two equal weights, but one which is counterbalanced by complexities of the determining factor. The length of the arms are different. The weights at the end of the arms are different. The fulcrum in between symbolizes the importance of impartiality and impartial judgment and attempts to balance the scales in an unbiased manner. The fulcrum, according to me, in the context of the judiciary, means the judge who must attempt to balance the scales to ensure that fair and equitable justice is done. The fulcrum is a central pivot in the scales of justice, symbolizes the importance of correcting imbalances and disadvantages in the legal system. This brings us to the question, what do you mean by impartiality? Does it mean that the judge has to be neutral? I have before me, if you look at the screen, two definitions of what is neutrality. I'll read the second definition first. We must always take sides. Neutrality helps the oppressor, never the victim. Silence encourages the tormentor, never the tormented. The opposite of love is not hate, it's indifference. In my opinion, probably this definition or this quote goes a little far beyond what the judges should do. I'll prefer the quote of Archbishop Tutu, which I'll now read. If you are neutral in situations of injustice, you have to choose the side of the oppressor. The importance over here is the emphasis on the term situations of injustice. If an elephant has its foot on the tail of the mouse and you say that you are neutral, the mouse will not appreciate your neutrality. This, according to me, should be the basis on which a judge should proceed when he deals with the question of, when he examines a matter and he decides that in this case, I have to take a more proactive and affirmative approach. At the same time, one has to be extremely conscious that we do suffer from internal and hidden biases and prejudices. In Thinking Fast and Slow by Daniel Kahneman, he explored two systems of thought that govern our thinking and decision making. System one, which is fast, intuitive, and emotional. System two, which is slow, deliberate, and logical. Invariably, invariably as judges, we should adopt the second system, but because it gives us far more better, fair, and equitable justice. I have before me given 6 types of biases. I'll just explain. These are sometimes hidden between us and we are not able to understand what sort of biases we can have. Confirmation bias. The tendency to seek out information that supports our existing beliefs and ignore information that contradict them. Overconfidence. The tendency to overestimate our abilities and the accuracy of our judgments and predictions. Anchoring bias. Tendency to rely too heavily on the first piece of information encountered when making decisions or estimates. Availability bias. Tendency to make decisions based on most recent or memorable information rather than more complete set of information. Hindsight bias. Tendency to believe that after an event has occurred that it was predictable or inevitable. Over here, I'll also like to mention that we often judge a person's conduct by our own hindsight or what is events and circumstances and experience we have had. We must remember when we are born, we are like a blank white piece of paper. But we do have our own textures and our own qualities. With the events happening in our life, with the experiences we have, the imprints are made on the paper. So every human being, in a way, when we decide and adjudicate, has different perceptions of what is right, what is wrong, what should be done, what should not be done in a particular situation. So hindsight bias, when we are adjudicating and deciding, our own experiences should not overpower us while we are dealing with or pointing out whether the person has acted rightly or wrongly. Framing effect. The way in which the problem is framed can significantly impact our decision making and our perception of the problem. In fact, if one carefully examines these biases and checks out on ourselves, it requires a self-introspection, self-discipline. One be able to help you in your decision-making process to reach out when you feel a person has come from an entirely different background or the facts of the case are fairly complex and difficult. I have in the next slide referred to Sukraniti, the system of morals. I'm not reading the last one, that the judge meeting or hearing a party to a case secretly is certainly offensive and cannot be accepted. But the first four are extremely important. Raga, leaning in favor of a party. This has to be somewhat absolutely avoided. Lobha, the greed. Bhay, the fear. Devesha, ill will against anyone. All these have to be checked, and when you check them, you are able to reach the right conclusion. The next topic which I want to discuss with you is with regard to a problem which has surfaced due to invent of transformation in the conventional media, internet, and the social aid, which is truth decay. This has happened because there's huge amount of false information, manipulation of data, use of sensational guidelines to gain larger audience. The rise of social media and abundance of online news sources, it has become easier than ever to manipulate public perception of truth. This results in distortion of representation of events and issues. While finding truth and separating grain from the chaff is already a mammoth task for all of us, truth decay makes it almost impossible to uncover the falsities and deliver justice. What happens in truth decay is there's increasing disagreement about facts and data. There's a blurring of line between opinion and fact. The increase in relative volume of and resulting influence of opinion over fact, declining trust in formally respected sources of factual information. This, I think, is one of the topics which has been kept by Justice Muralidhar for discussion. I like to just quote over here. It is a diagram which I have given. As there's increase in misinformation, there's declining trust in the facts. We are perhaps not aware of how it impacts our judicial working, but I'll just quote from Justice Sundaresh Menon, Chief Justice of Singapore, who had referred to and explained the adverse impact of truth decay in the courtrooms in the following words. Like advocates concealing facts, if truth decay is not controlled, then voice of judges will become another voice of clamor of opinions. And that is why often it is said that some judgments of a judge is a reflection of their personal opinion. Truth decay leads to destruction of trust in the judicial system. I had earlier referred to the procedural aspects, importance of the procedural aspects. We are all familiar with substantive rights. The procedural rights, that is method to protect the substantive rights, is one of the areas which we often sometimes ignore. And this is extremely important in criminal adjudication. The protection of substantive rights through the procedure is extremely relevant and important as far as criminal adjudication system is concerned. For it ensures, one, fair trial. Procedural rights guarantee that individuals are given a fair trial, which is essential for protection of their substantive rights. protecting individual liberty. Protecting individual liberty, procedural rights such as right to be informed about the grounds of arrest, right to legal representation, and the right to a fair trial are essential for protection of his liberty. Promoting accountability. By guaranteeing procedural rights, the judiciary is able to hold the government and the institutions responsible for their action. Strengthening rule of law. The rule of law requires that all individuals, including the government, are subjected to same legal processes and that justice is dispensed impartially. There was initially a lot of discussion what is meant by the procedure established by law. But after the decision in the case of Maneka Gandhi and other cases, it is now fairly well settled that the procedure established by law must not only be fair, just, and reasonable, but it must also be right, truthful, and clear. Now I'll go on to the specifics with regard to the criminal adjudication and the procedure. First aspect I'd like to highlight is Section 41A of the Code of Criminal Procedure 1973, which mandates issue of notice to the accused who is called for interrogation at the pre-arrest stage. This is a provision which ensures that the person who is summoned or asked to appear pursuant to the notice given by the investigating officer, though he is a suspect, does not feel isolated or intimidated. He can take whatever safeguards he wants to protect his rights as per the law. It keeps a check on the police aggression and abuse of power. It also avoids unnecessary arrests. It helps the accused gain vital and time-sensitive information or evidence of his defense, which may not be available with passage of time. It also protects the suspect from being subjected to wrongful self-incrimination, contrary to constitutional and statutory authorities. In this connection, I'll also like to point out earlier decision of the Supreme Court in Prakash Singh versus Union of India, which had established a police complaint authority, which had directed establishment of the police complaint authority. This judgment, this portion of with regard to establishment of police control authority somehow has not been effectively implemented in several states. The second aspect I like to point out is the recent decision of the Supreme Court in Satyendra Kumar Antil, which had dealt with the guidelines to streamline the process of granting bail. This says that bail applications ought to be disposed of within a period of 2 weeks, except if the provisions mandate otherwise, with the exception being an intervening application. Applications for anticipatory bail are expected to be disposed of within a period of 6 weeks, with the exception of the intervening applications. It also says that the compliance of the mandate under Section 436A of the Code of Criminal Procedure, as directed by the Supreme Court in Bhing Singh versus Union of India, should be followed. If one looks at, in spite of all these guidelines and the judgments of the Supreme Court, if one looks at the data, this is a pan-India data with regard to 2019, 20, and 21, one will find that as far as the ratio of under trials vis-a-vis the convicts is rather alarmingly high. And in fact, the total number of under trials has been gradually increasing. The latest figures show that out of 5 lakh, as far as 2021 show that as far as 5,54,034 inmates in the prison, almost 4,27,165 were under trials. In fact, there is also, the data also shows that there is an increase in the percentage of under trial prisoners. We have, in fact, in terms of the judgment of the Supreme Court in human conditions in 1382, listeners set up what is called under trial review committee. These committees are supposed to examine the persons who are in trial, who are undergoing trial, and wherever they are entitled to benefit of bail, then move applications for bail and ensure that those applications are listed and they are released. There are, in fact, this judgment lists out 14 categories of inmates who are entitled to the examination by under trial review committee and processing of their applications for jail. The district and session judge convenes the meetings of all UTRC members to consider the shortlisted candidates. I have the data with regard to this committee in the state of Orissa. As far as that is concerned, that would show that there were almost 18,221 under trial prisoners who could have taken benefit of that. There were about 1,556 URTC meetings, 6,867 UTPs were recommended for release, about 2,669 applications were filed, and 4,360 UTPs were released from jail. DK Basu guidelines for the time being, I'll skip. I think these are well known, but what has to be done is, at the time when the accused appears for the first time and is produced from police custody, we must ensure whether these guidelines have been complied with. It may be advisable at that stage to put a mark on the document produced by the police to show satisfaction of the DK Basu guidelines. The one aspect which I want to highlight and perhaps sometimes ignored is the importance of the case diary. Section 172 CRPC mandates writing and maintenance of a case diary. The police officer making investigation shall on each day enter the proceedings relating to investigation in the diary, including the time at which he began and closed the investigation, the places visited by him, and the statement of circumstances ascertained during his investigation. The statements of witnesses recording during the course of investigation under Section 161 shall be inserted in the case diary. There have been some very important amendments in it. One of the amendments says the case diary would be in volumes and duly paginated. The loose leaf case diary is no longer prescribed by law. Section 172(2) of the Code of Criminal Procedure states the criminal court may send for the police diaries of a case under inquiry or trial in such court and may use such diaries not as evidence of a case but to aid of it in such inquiry or trial. There are judgments of this court, of the Supreme Court, dealing with this aspect, and they have explained how the case diaries have to be used. During my term as a judge of the High Court, I had in 3-4 matters, because of the case diary, acquitted the accused. In the first case, accused had been convicted under the NDPS Act. When I went through the case diary, I found that the samples had been earlier sent to a laboratory and the laboratory had returned the samples saying the seals are broken. This fact was concealed. Unfortunately, the trial judge did not see the case diary and he had convicted him on the basis of a report which was subsequently obtained from another forensic lab. The second case was where a person had been convicted for murder on the basis of dying declaration, as well as certain evidences to show that there was matrimonial discord. The husband had died and the wife's brothers had been convicted. When I went through the case diary, I noticed that there were witnesses who had said that the husband had himself poured the kerosene oil and ignited the fire. That fact was completely concealed, not mentioned in the charge sheet or by the statements. Though this was the defense taken, during the course of cross-examination. The third case was one where a vagabond woman was found murdered, raped and murdered. The person who was prosecuted, it was a blind case, the person who was prosecuted was arrested after about 21 days. When I went through the case diary, I found that several witnesses and persons had clearly said that this person was not involved. In fact, he had been interrogated immediately after the occurrence, after the police had registered the case, but the stand of the prosecution was he was absconding, and therefore there was delay in arrest, which was contradictory. Case diary is the biggest check on the police investigation, fairness of the police investigation. So it's important when the accused is produced before you for the first time that the case diary is duly seen and also appropriately marked so that there cannot be any changes. This is the reason why it has now been mandated that the case diary was in volumes and duly paginated. I've already explained the importance of case diary, so I'll mix the next slide. There is also a requirement as far as witness protection is concerned. It started off with the judgment of the Delhi High Court in the case of Neelam Katara, wherein they had asked for establishment of, by court order, interim orders were passed for establishment of a competent authority to determine the need and extent and cost of police protection, assess the nature and risk of security of the witnesses, assess the nature and intensity of the investigation, assess the gravity of the testimony of the witnesses. Now we have the Witness Protection Scheme 2018. There are various guidelines provided in that scheme. I'll request all the district judges and session judges to just go through these guidelines. They are fairly detailed. They go on from a range of protections which are available, which includes temporary residence in a safe house, new identity, relocation, etc., etc. There's a problem which we face in criminal adjudication is that with regard to hostile witnesses. During one of the summer vacations, along with my law clerks, I had examined about 116 judgments, which I had authored in a period of about 8-9 months, and I found that in 44 out of the 116 cases, the public witnesses had turned hostile, the number being, if one takes in percentage terms, 37.9%. 27 out of 44 cases, which means about 61.36%, were those witnesses, public witnesses, which were material and important. In 18 out of 44 cases, which means about 40.41%, witnesses were completely hostile, while in 26% cases, that is 59.9% cases, they turned hostile during cross-examination. The 12 out of 44 cases, that is 27.27%, the crimes were against women or a girl child. Now, what is the reason why the witness has turned hostile? It may not be strictly within our domain, but it is of importance because ultimately we adjudicate and decide. There can be 3 reasons. Witness were threatened or lured, and there the witness protection scheme comes in, so we have to be cautious on that account. The police did not record true and correct statement under section 161, or the witness was planted. The third reason, again where our role comes in, witnesses do not want to depose because of personal reasons like friendship or relationship. This third aspect we have to take into consideration and we carefully examine when we discard these witnesses, completely discard these witnesses and ignore them. The other aspect which we have in the district courts or session courts have to take into account are the various schemes promoted by NALSA for the victims. These are Victims for Trafficking in Commercial Sex Exploitation Scheme 2015, Legal Services to the Victim for Drug Abuse and Eradication of Drug Menace, Legal Schemes of the Legal Services to Disaster Victims through Legal Services Authorities. There are in fact about 15 such schemes. It will be advisable that all of us go through those schemes and ensure compliances are made. You keep those schemes on your table, so whenever you require, you can take them out and enforce them. I have referred to some statistics with regard to the compensation awarded. I'll leave that for the minute. Then the next question, which has in the trial courts, which is important, is to understand the difference between a supervisory power and the corrective power. When to exercise the supervisory power as an investigation is concerned, and when to exercise the corrective power. There are statutory provisions which I have referred to: 156(3), 173(8), 202. The last aspect on which I want to emphasize is, this is something which is of some concern, is exemption from personal appearance. Most of us feel that appearance in the court is mandatory, and the reason being that it is a term of the bail. But if one looks at the provisions of CRPC, what is the object and purpose behind personal appearance? Evidence against the accused should be taken in the presence of the accused. This means that the trial should take place in the presence of the accused and adherence to the principles of natural justice is made. If one looks at 205 and 317, these provides us enough guidance when the exemption from personal appearance should be granted. In fact, 317 is far wider. If a judge or magistrate is satisfied that personal attendance of the accused is not necessary, the court may dispense with his attendance. Let us not forget that many times when the accused appears in the court, the cases are simply adjourned for want of evidence or want of documents, etc. But what happens also is, he loses his daily wage, and for him then it's a problem, because many of them are already who are facing the prosecutions are also face the hostile environment as far as employment is concerned, the social stigma is concerned. So wherever you feel that the accused will not abscond and will be present on the date and time when he is required to be present, and the trial has got prolonged, and insistence of the accused to appear in person is not really required because he is adequately represented by a counsel who is handling the matter, it should be exercised. I was pleasantly surprised by Justice Mulidhar when he said that this is a conference where the district judges will come out openly and speak. This is a very welcome step because there has to be interaction where the district judges are able to say out and speak out what the problems they have, what are the good practices they have adopted, and what should be the further course of action. This breaks the hierarchy in the judicial field and also helps us work as a family, because ultimately, if the adjudication and decision making at the first stage is fair, just and equitable, the burden on the high courts as appellate courts gets reduced. If one looks at what has happened in the West and how they've been able to control the floodgates in the appellate courts, is that the adjudication and determination at the first stage is top quality, is the finest. If that is so, a lot of the docket explosion which we find in the High Court and the Supreme Court is taken care of. Thank you so much. It's been a privilege speaking to you.
Thank you, my lord, for such treasured and inestimable thoughts on the release of Annual Report 2002, District Judges Conference, highlighting the importance of district judiciary, checking morals, remaining cautious over the news on social media, when to exercise supervisory and corrective powers, implementing witness protection scheme for better adjudication, importance of case diary, rights of the accused, strengthening rule of law, and highlighting various judgments of Supreme Court on the above aspects. Thank you, my lord, for sharing your valuable thoughts and gracing this occasion despite your lordship's busy schedule. As a token of our reverence, humble appreciation, and gratitude, we would now like to present a memento to our honorable chief guest. It would be my utmost privilege to request Dr. Justice S. Muralidhar, Chief Justice, High Court of Orissa, to present the memento to His Lordship, Honorable Mr. Justice Sanjeev Khanna, Judge, Supreme Court of India. Now, we proceed to the end of the program. I'd request His Lordship Honorable Mr. Justice Shashikanta Mishra, Judge, High Court of Orissa, and member of the Annual Report Committee, to kindly present the vote of thanks. My lord.
Namaskar and a very good morning to all. Esteemed dignitaries on and off the dais, ladies and gentlemen. Today we have witnessed the simultaneous launch of two important events, the District Judges Conference 2023 and the Annual Report 2022. Undoubtedly, there is a special significance to this fusion of two events in as much as in the District Judges Conference spread over 2 days, we shall make sincere attempts to resolve the specific issues faced by the district judiciary by way of deliberations and discussions, while in the form of the annual report, we have come forward to inform all concerned what was actually done by us in the past year and what our plans are for the future. The District Judges Conference is intended to provide a forum to redefine and reinvigorate our efforts to achieve higher goals. Similarly, the annual report, far from being a document of self-glorification, is an honest self-appraisal of our own efforts in the past year. The very fact that a sitting judge of the Supreme Court of India has graced this occasion bears testimony to the importance and significance of these two events. I therefore, at the outset, and on behalf of my sister and brother judges of the High Court, the district judges, judicial officers, and all others, express a deep sense of gratitude to Honorable Sri Justice Sanjeev Khanna, Judge, Supreme Court of India, for having found time from his busy schedule to be here with us. Your Lordship's gracious presence and highly educative and illuminating address today has been the most encouraging and inspiring for us, apart from being an eye-opener with regard to criminal adjudication. Thank you, my Lord. The idea behind holding the District Judges Conference in the form that we see now and the annual report was conceptualized by none other than Dr. Justice S. Muralidhar, the Chief Justice of Orissa High Court. Not only did he conceptualize it, he personally took care to design it, going into the nitty-gritty of each session of the conference and each chapter, sentence, and photograph of the annual report. I, on behalf of all present, express my sincere gratitude to His Lordship for his able stewardship of the entire team, as also for his kind address today. Thank you, sir. I also thank Honorable Sri Justice S. Tarapatra, Judge, Orissa High Court, and Chairman of the District Judges Conference Committee, for his personal involvement and monitoring of the arrangements made for the conference, including selection of the topics for the business sessions. I express sincere thanks to him for this, as also for his welcome address today. Thank you, sir. I thank Honorable Sri Justice Krishnaram Mahapatra, Judge, Odisha High Court, and Chairman of the Committee for preparation of the annual report. As in the previous edition, this year also, His Lordship led the team from the front by personally overseeing each and every aspect of the preparation of the annual report. Thank you, sir, for your leadership, constant encouragement, and kind presence today. I also thank the other honorable members of the District Judges Conference Committee and the Committee for Preparation of the Annual Report for their efforts and presence today. I thank my sister and brother judges of the High Court for their kind presence, which as usual serves as an encouragement to all concerned. I thank the former judges of the Honorable High Court for their presence, and I must tell you, your presence means a lot to us. I thank the learned Deputy Solicitor General of India for his presence. I thank the participating district judges and the judicial officers for their presence. I thank the office bearers of the High Court Bar Association for their presence. I also thank the members of the Registry of the Court, led admirably by the Registrar General. And I can assure you, all of them have literally spent sleepless nights to bring these two events to fruition today. I thank the officers of the state government for their presence, the member secretary of the State Legal Services Authority and his team, the director of Judicial Authority and his team, the director of Judicial Academy and his team, and all the support staff, without whose active efforts the program would not have been successful. I thank the trainee judicial officers for their presence, and I'm sure they shall learn a lot in the next 2 days. I also thank the members of the 2 subcommittees constituted for the annual report, for collection and collation of data, and editing and designing for their valuable contribution. I also take this opportunity to thank Sri Mohindra Mudali and Soumya Prakash Pradhan of Canon Fire for the wonderful job done by them in designing and printing of the annual report. I thank Ms. Panchami Manu Ukil for providing the write-ups for the artworks section of the annual report, and Sri Avinash Khemka for providing us with wonderful photographs incorporated in the annual report. And also Sri Samyak Mahanti and Ms. Tanuja Meghamala for their valuable assistance. Last but not least, I thank the friends from the print and electronic media for their presence and continued support. Once again, a big thank you to one and all. Namaskar, Vande Utkal Janani.
Thank you, my lord, for your kind and inspiring words of support, appreciation, and encouragement. Thank you, my lord. I would now request the Honorable Chair to declare the inaugural program as closed, sir. Now the ceremony is declared closed. Before we leave, may I now request the guests on and off the dais, participants and audience to kindly rise at their respective seats to pay their respects during the rendition of the National Anthem of India.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Now I request honorable judges, honorable dignitaries on and off the dais, participants to kindly assemble at the portico of Odisha Judicial Academy for group photographs.